On October 15 of last year, he admitted. On October 15 of last year, he admitted 3 to attempted felony assault, felony 3, and to tampering with evidence of felony 3. Was there more to the plea bargain than that, Mr. Meyer? Was there more to the plea bargain than that, Mr. Meyer? Right.
2 third-degree felonies.
Notes here about misdemeanors. Right. I did not. I have some notes here about misdemeanors, but he did not.
No, Mr. Dugan pled guilty to first degree. Mr. Dugan pled guilty to first degree. But there were a couple of terms that applied to both.
Again, on October 15, that was Mr. Evans. Again, on October 15, that was Mr. Evans's guilty plea. On the same date. On the same date, Mr. Dugan pled guilty to Mr. Assault count 4. Pled guilty to attempted abduction count 1. I'm sorry. Attempted abduction and assault count 4. A misdemeanor 1. And assault. Thereupon, misdemeanor 1. Pre-sentence reports were thereupon. Pre-sentence reports were requested. Both of those reports were prepared by the investigator. Both of those reports were prepared by the investigator. 12 for Mr. Evans and 12 to Mr. Evans. And number 13, I have read and reviewed those reports, and I have read and reviewed those reports, and thus would like to make a additionally, sensing memoranda were filed. Additionally, sensing memoranda were filed. I read those as are already of record. I have read those as are already of record. Told that Mr. Dugan been told that Mr. Dugan find that on the docket, so I cannot find that on the docket, so I had to be candid and say I have not read it. And as mentioned, Mr. DeVos, and as mentioned, Mr. DeVos, given the fact that guilty pleas, he may be referred to, given the fact that guilty pleas, he may be, as I understand, also present, as he is, as I understand, also present, as he is. So with that general introduction, I'd be happy. So with that general introduction, I'd be happy to hear. Thank you, Your Honor.
The state has 3 exhibits that we'd like to consider. The state has 3 exhibits that we'd like to consider in addition to our argument. I'll briefly summarize. What happened here on March 24th, 2019? What happened here on March 24th, 2019 was Timothy Nicholas Evans working in the Cuyahoga County Jail. Timothy Dugan. Mr. Evans was one of 4 corporals on jail that night. Mr. Evans was one of 4 corporals on jail that night. Mr. Evans' responsibilities included supervising. Mr. Evans' responsibilities included supervising the 7th floor corrections officers, as well as a 7th floor mental health unit, as well as multiple other floors. So he was the manager in charge of both inmates and corrections officers, and the decision maker about what happened in the jail that night. Mr. Dugan was assigned to the 7th floor mental health unit. The victim, Terrence DeBose, had been picked up and charged with burglary, felonious assault, and I believe possession. And he had a lengthy history of mental health problems that were well documented in the court's file and in the jail file. Schizophrenia, paranoid schizophrenia, bipolar disorder, he had a substance abuse addiction, and he is suffering from post-traumatic stress disorder. When he was brought up to the 7th floor, he was very vocal about the fact that he needed to be placed into a cell where he had a bottom bunk. He could not go on a top bunk, and that triggered his psychotic thoughts. And so he was put into a cell with a top bunk and immediately began protesting. He plugged up the toilet, he stripped naked, he covered his body with toothpaste, and he began banging on the cell window. And a little after 7 p.m., guards responded to the 7C pod where Mr. DeBose was housed. And we have body camera from Corporal Evans. As the jail policy requires, when he responded to a critical incident, his body camera was running. He walked over with an SRT officer, and then Mr. Dugan responded as well to the area, and Mr. DeBose was removed from his cell. And we know from the body camera that Mr. DeBose was verbally abusive. I mean, he was swearing at the officers, he was saying very nasty things about their family members, and it's the sort of thing that you would expect from a psychotic inmate who's having a mental health breakdown. He did not offer any physical resistance whatsoever. If you inspect that body camera video, you will see absolutely no physical resistance. He is is removed from the cell. He's cuffed in the cell, taken out of the cell, and walked to a restraint chair. He's placed in the restraint chair, and Corporal Evans and the SRT officer strap him down to that restraint chair. And I'm not sure if you've seen one of these in person, but he's got straps that go around his arms and around his shoulders and head area and legs, and he is immobilized to that chair. Mr. DuBose is naked, and there's toothpaste from a small toothpaste tube covering his chest, his hands, and his face. Officer Dugan puts a blanket on his body. You can see from the body camera video that he's wheeled out of that pod into an isolation room nearby. And under jail procedures, when you have an inmate who's a danger to himself or others, and he's in a restraint chair, he's supposed to stay in that isolation room until the situation de-escalates and the inmate is calm. You can see him wheeled into that into that isolation room in the restraint chair by Corporal Evans, and that will pick up in what I'm going to call State's Exhibit 1. And I'd ask that you view State's Exhibit 1. It is the surveillance video.
If I may interrupt you, before you play it, I trust your opponents have seen this?
Yes, it's been provided in discovery, and I've spoken with both opposing counsel and explained the exhibits that we're going to be presenting this morning.
Object, Mr. Dixon?
No, Your Honor, we haven't been provided with that.
Mr. Chaluka?
No, Your Honor, we've been provided and have reviewed this evidence.
And again, before you play it, I trust there's no audio on this, right?
There's not. However, there will be audio in a subsequent recording of the playing.
That you want to play?
Yes.
What I always tell the lawyers then is when a video or a tape recording is played, I do not demand of the court reporter that you try to memorialize the things that are said on the video. So if when you play the part with the audio, there are certain things you want to make sure are clear on the record, you might want to say something like, you can see at 1 minute and 10 seconds of this audio, so-and-so says such and such.
I will pause the video and try to incorporate into the record the salient points that the court should consider.
So you're welcome.
Thank you, Your Honor. I'm going to play this first at 1-to-1 speed. So
And
this is
before you, and I'm sorry, before you start. So this is after being brought out of the cell and being taken into what you call the isolation?
the isolation room, correct. And you'll see Corporal Evans wheel Mr. DuBose in, and I'll let the video play and explain a little bit what we're seeing.
And before, one other thing before you go, I know I keep stopping you. If anybody on the defense side needs to move so they can see, they're welcome to please.
Thank you.
And I will also say this, we've talked extensively with Mr. DuBose. This video is disturbing to Mr. DuBose. He's indicated that he would like to try to stay throughout the proceedings, but it is bringing back some very traumatic memories for him, and it may be necessary for him to leave the courtroom. And I would just ask the court's indulgence if it reaches that point that he be allowed to do so.
Yeah, he's welcome to do that, obviously, without disrupting whatever else is going on.
So you can see Mr. DuBose, he's got toothpaste on his hands, on his chest, and on his head. He's been placed in a spit mask. I believe Officer Dugan indicated that as they were taking him from the cell area to the isolation room, he tried to spit on them. I have one of these spit masks here today. And the thing I would ask the court to consider is just the claustrophobic and restraining effect psychologically on what he's going through, because that spit mask is very tight on his head, and he's tied down to that chair. He cannot move. So as this is happening to him, he's experiencing this from the standpoint of a person who is completely immobilized.
So from my vantage point, it almost looks like he's wearing surgical gloves, but that's toothpaste.
That's toothpaste.
Pardon my English.
And in speaking with Mr. Dugan, who we have talked to and has been very cooperative and helpful, he explained that this is a fairly common occurrence with inmates who are preparing for a physical altercation. They use soap or some substance to essentially grease them up so they're harder to handle. So there is some rationale to it. It seems bizarre and somewhat psychotic, frankly, but there is some rationale to it. what's happening here is that Mr. DuBose is continuing to hurl epithets at Corporal Evans and Officer Dugan.
What do the rules of the jail say about whether you could just take a person like Mr. DuBose, put him in the isolation room, and get out of there?
Well, I'm not sure that you have a hard and fast rule about whether the officers should remove themselves. I mean, their responsibility is to keep the inmate safe and make sure that no harm comes to the inmate or others. But as you see from this evidence, Mr. Evans is clearly upset. You can see from his stance, you can see from his balled fists, and if you review the body cam video, you can hear him talking to Mr. DuBose and getting more and more agitated as Mr. DuBose is talking about his wife and about family members and wanting to fight him, and that's what's going on here.
Well, that's why I asked whether the rules or the protocol permit the officer to just leave the room and mellow out for a bit.
There's nothing in there that would stop that from happening, and a timeout in this case would have been far better than what happens next, which frankly is torture. And you can't see it, but Officer Dugan is in the vestibule area of the doorway. That's his hand there. Now what just happened there is Corporal Evans reached up and turned off his body camera. Up to that point, we had both video and audio of what was happening between the inmate and Corporal Evans and Officer Dugan. As soon as Corporal Evans turned off that body camera, this is the only evidence that we have. So we don't know what got said after this point, other than talking with Mr. DuBose, Mr. Dugan, and Mr. Evans. We have no evidence of this.
Do you mind going back a second or two? I was focused on the hand at the bottom of the screen. I didn't see what...
Right there.
Okay, I
And this was a very disturbing moment for investigators as we evaluated this, because we have a surveillance video of an officer tampering with evidence in real time as he's about to commit an act of brutality on a restrained, defenseless inmate. And when we asked Officer Dugan in particular why this would happen, why the corporal would turn off his body camera with a surveillance camera right up on the wall, the answer was you get used to the surveillance cameras to the point that you don't even realize they're there. But that being said, the body camera still deprives us of crucial evidence. It deprives us of whatever Corporal Evans said to inmate DuBose, which I would suggest from the body language was equally disturbing. When we slowed this video down and analyzed it, we counted 6 blows inflicted by Corporal Evans and 2 blows inflicted by Officer Dugan. The blows caused Mr. DuBose's head to jerk back and forth in that restraint chair because his head and neck are essentially immobilized by the shoulder restraints. Mr. DuBose explained that it caused him to see stars, and he said he had never been hit that hard in his life. Corporal Evans stays with Mr. DuBose for about another 2.5 minutes. A nurse comes in at about the 7:27 mark, takes Mr. DuBose's blood pressure and leaves, and then the last thing that happens between Corporal Evans and Mr. DuBose is that Corporal Evans removes the stick mask and leaves the room. And there's no further interaction between Corporal Evans, Officer Dugan, and Mr. DuBose. Mr. DuBose is left in the isolation room naked with that blanket covering his lower body for another approximately 3 hours. He then is taken up to the medical pod And that's where I'd like to pick up the State's Exhibit 2, because we do have body cam from the sergeant who was on duty that night, Sergeant Tony, who's responsible for the corporals underneath him. He's essentially the ranking officer in charge of the entire jail who responds and handles Mr. DeVos. And I'd like to play that video next if I could. And I've referred to that video as State's Exhibit 2.
I trust your opponents have seen these.
Yeah.
Object, Mr. Dixon?
No, Your Honor.
Mr. Chalupa?
No, Your Honor.
And just a word of caution, Your Honor, there's going to be some extremely strong language here. This is a disturbing video, and I want everyone to be aware of what they're about to see, because this is, in particular for Mr. DeVos, difficult stuff.
I've probably heard some of these words before, but I'll try to hold on to my composure.
Thank you, Your Honor. Mr. Susan is especially sensitive, so.
No doubt.
I'm coming in 1 second.
For the record, the time code is 2224. It's 1024.
That one dude beat me, hit me over here, beat me on this side. I was in strings. All I asked is, I don't want to be on. I said, this is what started this. I knocked on the door. I said, I don't want to be here. I said, I'm dangerous, man. I said, I feel already, I'm end up killing one of these people here. I said, can you move? I want to bottom. This is what started. I knocked on. I said, how you doing? I said, I would like to be moved to a different, cell. And it's just, then he put me in these cuffs. I talked about his mom and everything. He got offended, and they beat the fuck out of me.
Let me bring this up.
Listen, bro. They beat the fuck out of me.
Well, hang on, let me get you away from this wall. Let me get you away from this wall.
Pausing the video there, Your Honor, one of the things that we'd like you to draw attention to is Sergeant Tony's demeanor with the inmate. You're going to hear, and I'm sure you have heard, that during this time period, the jail was in essentially a crisis, where you had too few officers responsible for too few inmates under conditions that caused people to snap. And that is, to an extent, true. But there are professional people in that jail, and it's the majority of the officers who safeguard the inmates day in, day out. And Sergeant Tony is one of them, working under incredibly difficult circumstances. And you'll see how he redirects Mr. DeVos and de-escalates the situation. It does not allow Mr. DeVos' behavior to affect how he handles the situation in any way. I think that's important as you evaluate the behavior of the two defendants who have committed crimes in this case.
Network, man, if you look on that camera and you see them dudes hit me from the right, from the left, man, I see the store, bro.
Listen to me. We're going to go
I
down.
ain't
I'm
got
going
no
to take you
phone
to
to
see.
see to call my mom.
Oh, here, listen.
I'm on the phone. I have to have a phone call. Can I please have a phone call?
In the middle of the night, it might be a little bit
No,
rough.
that's not fair, man. Can I please, sorry.
Will you listen to me for one? I'm Sergeant Tony.
Sergeant Tony, please.
First things first, let's get you down to medical.
Okay, why would you beat me in this for 4 hours, man? I've been in here about 4
And
hours.
from there, we'll go forward with anything else, all right?
This is not right, sir. Y'all denied me medical treatment. When the dudes came in here and beat the fuck out of me, I couldn't even feel my fucking head. It hit me from this side, that side, hit me in my nose. Listen, bro, I've been asking for medical treatment ever since they did this. You hear me?
I
Dude
hear
came
what
in
you're
here and
saying.
apologized to me. I told him I don't want his apology. The one with the beard, he is the first one that smacked me. He smacked me, then he followed up with a bunch of, man, the other dude hit me so fucking hard, I seen scars.
Well, first things first, let's get you down to medical.
Man, do you know I am a mentally retarded person, man?
What kind of status are you on? I see you got the blanket. Are you on full precautions, or what are you on? Do you know what your precaution status is?
I don't understand what you mean.
How they have you with just a blanket on?
Because I took all my clothes off.
You
Because
took
I
them
didn't
off in the
visit.
cell?
No, this is what happened.
I'm just trying to figure out.
I've never been on a, what they call a bottom. I always get a bottom bunk because of my mental illness. I knew this wasn't, I knew that, ooh,
What's the white stuff all on you?
toothpaste.
Toothpaste?
Yeah.
Alright.
But why would they So why would they hit me like that, man? Can you explain to me what would make them that upset? I mean, I'm mentally, I don't know nothing. I don't know my right from my left some days. What would make them hit me like that, brother? Man, they beat the fuck out of me, bro. What would make them hit me? I am mentally retarded. Well, yeah, they beat the fuck out of me. Can you answer that? Listen. Can you please talk to me and answer me?
I'm gonna talk with you, but
That I
first
was
things,
born, no, brother.
the nurse to check you out.
Listen, you have to talk to me. Because I don't understand. Can you take this off? I'm in pain. I'm not going to do it. This is not fair, man. I've been in this chair. I'm freezing. Listen.
First things first, let's get you
Sergeant.
seen the nurse.
Sergeant.
Hang on one second.
Sergeant.
Let me explain to nurse
Sergeant.
what's happening.
Sergeant. Why would them officers hit a mentally unbalanced person like, man, they was hit. No. And they beat the fuck out of me in the restraint chair. Say it right. Get those cameras. Listen, the corporal beat me. The corporal smacked me first. Then he beat me. Then the other guy on the car, he beat me. I mean, they beat me. I seen stars. I mean, they beat the fuck out of me. And when I say beat me, they beat the living shit out of me. They beat the fuck out of me. I thought I was gonna die. And I asked for medical treatment. I haven't had a phone call. They beat the fuck out of me, ma'am. Ma'am. They beat me. I'm mentally unbalanced. I was born this way. It's not my fault. Why would you beat on me? Why? Listen, they beat listen, ma'am, I couldn't believe they beat me that bad. I never been beat that bad, man.
I'm gonna move this.
Listen, ma'am.
Just
Ma'am, I never in my life,
speak, but
I was
still
getting
see
3
nothing
fights
happening to
probably
him.
my whole entire life. I have never been supposedly beat.
And just for the record, Mr. Bose for several minutes has been in a evaluation room in the medical pod of the Cuyahoga County Jail. The time code is now 22:30. And I think what's important here is not to sensationalize what's happening with Mr. DeBose, but he's in the midst of a true mental health breakdown. And he's exhibiting some of the symptoms that required him to need medical care and need psychiatric care. He's also very loudly complaining about his injuries. And there's going to be to a certain extent, an attempt to minimize those injuries and debate whether this amounts to serious physical harm. When the state evaluated this evidence, looked at what was happening in this tape, and spoke with the doctor who ended up evaluating him a week later, it was not until a week later that he finally saw a doctor. The doctor's conclusion was that what happened to his head and neck and the symptoms he was describing were consistent with post-concussion syndrome. And the reason I'd like the court to evaluate this tape, I'd like to continue playing until about the 10-minute mark, is to listen to him describing the symptoms and focus on the severity of his injuries as he's describing them.
Yeah.
is a little difficult to hear, but what he's doing is he's sobbing and he's begging to be taken to a hospital to have his head evaluated because of his injuries. For the record, I'm stopping the tape just after the 10-minute mark at time code 223415. And again, this was, I believe that date stamp may be incorrect, though, Your Honor. It indicates March 22nd, 2018. The focus that the state would like the courts to draw attention to, though, is that after the video stops, Mr. DeVos gets a couple of Tylenol, he has his blood pressure taken, and after a period of time when he calms down, he is taken out of the restraint chair and given clothes to wear and taken back to the cell. He does not receive any further medical treatment other than a few nurse evaluations throughout the next week, and the nurses noted additional psychotic or disruptive behavior. But it was not until a week later when Mr. DeSimon contacted Dr. Tallman, the jail's medical director, that this incident was actually scrutinized and evaluated by a medical doctor. That was the first time that a doctor even was aware that this happened. Dr. Tallman immediately brought Mr. DeVos back up to the medical pond, evaluated him, noted the post-concussion symptoms that we've described, and took him to Metro's main hospital where he got a CT scan for his neck and for his head. Mr. DeVos, when we talked to him in October, we drove out to Bowling Green, and he described continued headaches because of this incident. And looking at the security video of that isolation room, you saw his head whip back and forth as these officers were pummeling him. I submit that it's no stretch here to call these injuries serious physical harm. They're something akin to what would happen to a person in a car accident when they get whiplash. And no one would dispute the reality of those injuries. So attempts to minimize what happened to Mr. DeVos here, I think, are frankly demeaning. They demean the seriousness of the offense. And they certainly demean Mr. DeVos and what he went through. This is the Cuyahoga County Jail in 2019, March of 2019. After the jail has fallen under intense scrutiny by the Marshal's report. It's about 10 months after the state of Ohio, this team of investigators were investigating conditions in the jail. Everyone in that jail knew that they were under a lens, and their behavior was under close scrutiny. And yet this third world behavior is happening. It's no stretch to call this torture. And anyone who would say that I'm exaggerating that or stretching that should strap themselves into a restraint chair and volunteer to get pummeled with a spit mask on, just like Mr. DeVos, and then tell me it's not torture. I would ask the court to consider State's Exhibit 3. This is a snippet of an interview, and again, this has been played for the defense. It's been provided to the defense in discovery. And we asked Mr. DuBose what he would like to have happen in this case. We anticipated that it would be difficult for him to come back to the Cuyahoga County Jail, and I think it's worth considering his words in October, although he does have the right to make a separate statement today.
Before you play it, object, Mr. Dixon.
No, Your Honor, we have been provided with this, and we don't object to that.
And Mr. Chalupa.
No, Your Honor, we have also been provided this and have reviewed it.
What would you like to happen in this case with these two?
Well, I do forgive them because I know how it is to be forgiven for some things we did. Because maybe, like the incident that I did, I didn't mean to do it to that guy. So I feel that I just forgive them. I just think maybe they should get maybe a year or something.
A year in jail?
Yeah.
You think they should experience incarceration?
Yeah, because I didn't do nothing to deserve that.
And not work at the jail, right?
Yeah, not to work at that jail.
Okay.
But I feel that they do deserve something because I didn't deserve that. I didn't do nothing but just wanted a bed. I didn't want no food. I didn't want no special treatment or nothing. All I wanted was a bed. You beat the crap out of me just because I wanted Lord Rat. You know what I'm saying? And I wasn't. But I do forgive them.
Do you have a problem sleeping on the upper bunk?
Yes, I does.
Yeah. A lot of guys do. And how are you doing these days since you come here to Northwest?
With a new medication that they gave me, I like it. I've never been on this kind of medication, and it keeps me calm, and I could go to sleep on that shit real quick.
What are they?
Because I used to think
The Seroquel?
a lot of stuff was going through.
I think, in addition to Mr. DuBose's requests for the court to consider, I'd also ask the court to also evaluate Mr. DuBose's demeanor on that tape. That's a very different man than the one who was having the crisis in the Cuyahoga County Jail in March of 2019. And we certainly cannot solve the problem of mentally ill people coming to the Cuyahoga County Jail and the jail's ability to deal with that issue. But we are here to consider whether the two defendants in this case who behaved brutally and dishonorably are deserving of a particular sentence. We would ask you to consider Mr. DuBose's wishes first and foremost in forming that sentence. I will also state for the record that despite his conduct that evening, Officer Dugan has been cooperative and open and direct with the state, and we do anticipate calling him as a witness in subsequent trials. What happened in the Cuyahoga County Jail begs for public accountability. It begs for the criminal justice system to scrutinize and hold accountable everyone who committed wrongdoing. And Officer Dugan, to his credit, is willing to assist the state in doing that. So we have drawn a line between Officer Dugan and Corporal Evans, and we think that's something the court should consider.
Are you suggesting that what we saw this morning is not anomalous in that jail?
I can't give you a guess. I think it would be irresponsible to guess. I can only go with the evidence that we have. And what happened here that you see on that tape was, to a degree, premeditated by Corporal Evans. And that's why I think Corporal Evans is deserving of greater punishment than Officer Dugan. Corporal Evans was in charge. He set the tone. He was responsible for the safety and well-being of the inmates, and he was responsible for the conduct of the officers who served under him. And you saw on that tape that he went through a thought process. Even though he was under a stressful situation and he was losing his temper, he reached up and turned that body camera off because he knew he was about to do something brutal. And he did not want that body camera to capture the evidence of what he was about to do. And there's a thought process there. He didn't just snap. Now, Officer Dugan sees what Corporal Evans is doing to inmate DuBose. And to a degree, it's not right and it's dishonorable behavior, but he fell in line behind Corporal Evans, his boss. I think that carries a great deal of weight when you evaluate the sentence that you parse out here. We do recommend a term of imprisonment for Corporal Evans, and it's a weighing process. does the harm that Corporal Evans inflicted, not just on inmate DeBose, but on the institution that he served, on the laws that he was supposed to uphold, the reputation even of Cuyahoga County and its ability to safely house inmates who are in mental health crisis. That weighing process we submit it calls out for prison, because a sentence of less prison will send a message that what happened here is not that serious. And it is one of the most serious things that a public official can do, and that's care for the safety and well-being of powerless people. Inmates like Mr. DeBose have no power whatsoever. The guards have the power, and when they brutalize and torture inmates, it has to be dealt with. Criminals thrive on the indulgence of society's understanding.
Anything else, Mr. Meyer?
I would like to also make a couple points about other cases that we've brought before the Court of Common Pleas. It's been mentioned in my colleague's brief. Former Warden Ivey, for instance. Former Warden Ivey was involved in a death investigation. An inmate named Joseph Arquillo died of an opiate overdose in the Cuyahoga County Jail. And that death was largely preventable, and that's the subject of a criminal trial that's ongoing in another courtroom that will happen in July. Warden Ivey responded to the scene as the ranking officer in charge of the jail, and after Mr. Arquillo, who was in the process of dying or may have already died, was put on a gurney and led out of the jail, Warden Ivey instructed the officers who were recording the scene to turn off their body cameras. Now, it was the state's belief that that was impermissible, violated policy, and then he lied about it. Warden Ivey, however, did not tamper with evidence to conceal or hide evidence of violence or brutality. And that is a world of difference between what happened in that case and what happened in this case. And Warden Ivey, also to his credit, has cooperated with the state and will testify in upcoming trials where we're asking courts to hold people accountable who are over top of him. And again, that's something that the state factors in when we evaluate how to deal with these cases. Was there violence involved? Did the person take responsibility? Are they willing to cooperate and undo some of the harms that they caused? That's very different than Corporal Evans. Your Honor, I also draw attention to the recent case of John Wilson, which I prosecuted. That was a very difficult case to prosecute because we did not have video. We had an inmate's word against an officer's word, and we had brutal, horrific injuries. We went to a trial in this building in front of a jury, and a jury hung on the most serious counts, 11-1 for acquittal. I worked with my colleague, Mr. Bergen, who's in the courtroom today, to settle a difficult case. It is by no means a reflection of the state's view of the seriousness of that conduct or whether this defendant deserves to go to prison for his crimes. It's a separate case. It has no bearing on what happens here. And in a court where the rules of evidence applies, evidence of compromise is not admissible. So I object. And I would also ask the court to consider a case that's going on just across the hall from you. A corporal named Idris Fareed Clark, who also, we submit, engaged in criminal acts and has pled guilty to abusive behavior towards another inmate who was tied down in a restraint chair and who also will be sentenced by your colleague, Judge Dick Ambrose, on March 9th. We filed a sentencing memo substantially identical to the one in this case. Corporals who inflict violence and instruct their subordinates to fall in line and also help them inflict that violence deserve to go to prison. It's not inconsistent for the state to take that position. I would defy any prosecutor in America to say that what we're doing and what we're asking for is unreasonable. I believe I've made my points, Your Honor. I'm not asking for a specific term, but I am recommending prison for Corporal Evans. I take no position on Officer Dugan. I just ask that the court consider all the facts before letting a sentence both. At this point, I would ask that the court hear from the victim and the victim's representative.
So it's worth noting that Mr. DeBose is present with his lawyer, Paulo Cristallo. Mr. Cristallo, I have seen Mr. DeBose's name spelled two ways. Is it D-E-B-O-S-E?
Yes, it is, Your Honor.
Okay, thank you. And does Mr. DeBose wish to make a statement before Mr. Evans and Mr. Dugan are sentenced?
Your Honor, Mr. DeBose has asked me to read a statement, if that's all right.
Yeah, if you'd approach the podium, I will be grateful. We'll put it in on the spot. So, good morning, Mr. Cristallo. and Mr.
Good morning.
DeBose.
Is the microphone okay?
Pardon me?
Can you hear me?
Yeah, okay. That's somebody else's microphone, but I can hear you
On behalf of Mr. DeBose, who's asked me to make a statement, Your Honor, I would like to begin.
Actually, before you do. Any objection to Mr. Cristallo reading or paraphrasing Mr. DeBose's words, Mr. Dixon?
No, Your Honor.
Mr. Chu?
No, Your Honor.
Please continue.
Thank you, Your Honor. Before addressing the full sentencing of the defendants in this matter, we feel it's important for this court to appreciate a small summary of Mr. DeBose's personal history. Terrence DeBose has struggled with mental health issues his entire life. He grew up in a brutal environment and was subject to physical and emotional abuse at the hands of more than one family member. From at least 8 years old, Terrence has displayed symptoms of mental and emotional instability. In fact, medical professionals have diagnosed Terrence with schizoaffective disorder and bipolar disorder, in addition to other conditions. And in order to fully understand the impact of Terrence's mental health issues, we must consider the context of a young man growing up in poverty without a supportive family or social network. As a result of this all too familiar scenario, whereby a young person with mental health issues fails to get the treatment they need, leading to abnormal behavior, Terrence DeBose has on more than one occasion found himself locked up behind bars in the Cuyahoga County Jail without the basic protection and necessary oversight afforded to him by the Constitution of the United States. In this instance, and as evidenced by the fact that Mr. DeBose's underlying case was placed on the mental health docket, Cuyahoga County was fully aware that Terrence needed treatment, medication, and some modicum of compassionate protection. He received nothing of the sort. Rather, Mr. DeBose was subjected to a brutal and inhumane attack by the very hands of officers who were sworn to protect him. The video of Mr. DeBose's beating conduct goes beyond the bounds of human decency, and as a result of this attack, Mr. DeBose continues to suffer. He has a serious injury to his head that was diagnosed as concussion syndrome, along with lasting symptoms accompanying such attack. He continues to suffer the consequences, including nightmares, headaches, trouble focusing, and flashbacks of having his legs and arms restrained while being pummeled about the head, face, and neck. Not only was he physically attacked by these officers, but immediately following this incident, Mr. DeBose was subject to further torturous conduct by being placed in isolation, naked, and directly under an air conditioner for 4 hours. He was denied treatment and medication for his injuries, and perhaps not surprisingly, he was denied that modicum of compassion. Not all of the guards and corrections officers and employees in the Cuyahoga County Jail are bad or rogue officers. There's a lot of good employees at the Cuyahoga County Jail. But in this instance, it goes beyond defendants Evans and Dugans in terms of people who failed to show or display a shred of human decency towards Mr. DeBose. It is no wonder that a man with pre-existing mental and emotional problems that has not responded well to being treated worse than an animal. Yes, Mr. Dugan and Mr. Evans today appear before this court to find out their punishment for their misdeeds. This court, which enjoys a reputation for thoughtfulness and impartiality and fairness, will impose the sentences it sees fit. But Mr. DeBose's definition of justice would include 3 additional factors beyond that punishment. First, Mr. DeBose would like this incident to serve as an example of what can happen in an institution when good people fail to stand up for what is right. For too long, the Cuyahoga County Jail has been an environment where many people were willing to look the other way in the face of abuse, neglect, and mistreatment. Mr. DeBose fully recognizes that there are many good corrections officers, medical personnel, and other jail staff in Cuyahoga County, but as detailed by the November 2018 U.S. Marshals Report, the jail has become fertile ground for unconstitutional practices, aided and abetted by corruption. It is no wonder that incidents like the one before the court occurred under these circumstances. As Martin Luther King Jr. once said, whatever affects one directly affects all indirectly. And so, the more we treat inmates like Mr. DuBose inhumanely, the more we lose our own humanity. Second, it is Mr. DuBose's wish that continued investigations be taken into the culture of corruption and inhumane treatment that exists within the penal system of Cuyahoga County. Because it should be quite apparent that if there had not been surveillance video in this case, Mr. DuBose's brutal attack never would have come to light. Think about that. Without this video, I submit that no one, no person in law enforcement would have believed an inmate with a history of mental health issues over 2 corrections officers. We can only imagine how many other incidences, unreported and or disregarded by internal investigators, have occurred in Cuyahoga County Jail as a result of the pattern of abuse and corruption. And therefore, part of Mr. DuBose's wish for justice is that this court, the prosecutor's office, the media, and the public at large, all of us consider that inmates and arrestees must not be dismissed out of hand when they report these serious crimes of inhumane treatment. Lastly, Mr. DuBose would like this incident to be considered a clarion call to provide necessary resources, support, and training for all corrections officers and staff in how to effectively and humanely respond to inmates with mental health issues and who are having mental health emergencies. Not only are the lives of inmates at risk, but this rampant unconstitutional behavior puts its own officers and staff at risk, as well as fostering an atmosphere of cover-up and subterfuge. It is fair to say that Cuyahoga County needs special training for its employees in how to treat someone when they are strapped in a restraint chair. Rather, it is Cuyahoga County needs no special training for its employees on how not to beat someone while they're strapped in a restraint chair. Rather, what is needed is training in the basic right and wrong, and how to react to someone who is suffering from a diagnosed mental health issue, like so many who end up in the custody of law enforcement. These individuals do not cease to be human beings once they are incarcerated. The Constitution of the United States and the laws enacted by the state of Ohio and Cuyahoga County demand a level of decent and humane custody that must be preserved, or lives in our democracy will be at risk. Finally, Mr. DuBose would like to thank the prosecution for their defense of justice in this matter. He would also like to thank the court for affording him this time and opportunity to be heard and to respect its responsibility in carrying out its unenviable duties. And finally, Mr. DuBose would like to express his appreciation to the defendants, Mr. Evans and Mr. Dugan, and the state for coming to plea agreements which evidence that the parties have taken a step towards accepting responsibility for their actions in this matter.
Mr. Meyer, is there anything additional that you wanted to elicit from the witness that hasn't been said before he's excused from the podium?
The only point that we made and will continue to make, and I think Mr. DuBose agrees with, is that his injuries and his psychiatric trauma constitute serious physical harm. And we believe that the attempts to minimize what happened demean the seriousness of the offense.
Do you have anything, Mr. Dixon, that would be in the nature of a cross-examination, which is kind of difficult to do given that the witness spoke through counsel, but is there something you want to ask either the witness or counsel at this point?
No, Your Honor, we thank you for that opportunity.
Same question, Mr. Chalupa.
No, Your Honor, thank you.
Mr. Cristallo and Mr. DuBose, thank you for being here today. One comment, Mr. Cristallo. You may have been reading from a prepared document. If so, before you leave today, could you give Madam Court Reporter a copy of what you had written so that she can assure herself that she got everything in?
Absolutely.
Thank you both.
Thank you, Your Honor.
And maybe I'll ask to state this, but Mr. Cristallo might be a person for this question. Is there any request for restitution in this case, in a criminal case?
Your Honor, I think that the restitution in this case would be difficult to define.
There's no known economic loss at this point?
Certainly his medical needs, which have been dealt with and attended to, but we're not prepared to set a hard number in this proceeding. I think that Mr. DuBose is likely to seek compensation from Cuyahoga County separate from the criminal justice system.
Right. Well, certainly a question had to be asked since we're at the criminal sentencing.
But certainly in terms of justice, I think Mr. DuBose and the state believe that what happened here deserves a harsh punishment.
Anything additional from the state of Ohio, Mr. Meyer?
No, thank you.
One question I had for you, I just want to have a thorough record here. When we started the hearing, I introduced the participants on behalf of the state as you and Mr. Susi. I have met your investigator, but I'm sorry, I forget his name.
My name is Bob Design. It's capital D-E, capital S-I-M-O-N-E.
Of the county sheriff's office?
I work for the county prosecutors, were assigned to the Attorney General's office.
Okay. And actually, one other question for the state before I turn to the defense. By the way, I think I'm going to take a short break before turning to the defense. You have asked that at least one of these defendants be incarcerated. If one or both are sentenced to a period of incarceration, ordinarily they are turned over at the end of the hearing to the Cuyahoga County Sheriff, and they're taken to the jail. If it's a jail sentence, they're kept there. If it's a prison sentence, they're transported, but they spend some period of time, 5, 7, 10 days in jail. Is the Cuyahoga County Sheriff, the Cuyahoga County Jail, prepared to receive and, I must say, protect these men?
We have spoken with jail and sheriff's officials in other cases, and what we've done and what we asked the court to order is that if the court remands the defendants to custody, that it order that the sheriff transport them, if there's a need to spend any time in the jail, that it be at Cuyahoga County Jail or one of the surrounding counties, not Cuyahoga County. They'd be at the jail where their colleagues worked and where other inmates would know what they did, and I think that would be a safety and security problem, housing them in the Cuyahoga County Jail. And I'd also ask the court, if it does incarcerate one or both defendants, that it order that the Department of Rehabilitation and Correction place them in a facility where they're in protective custody, because there would be a security risk.
And what about, though, if these gentlemen or one of them are sent to prison? Is it your suggestion that there be a report day, sort of like they do in the federal system?
I'll defer to the court.
Is there, I will say that I don't think that I've ever done that on a prison sentence in state court. Is there a means of doing that? Can the ODRC accommodate that?
I'm not aware of a law that says that cannot, and if that's the court's orders and wishes, we'll facilitate it and make it happen. I would say, though, that if the court orders a report date, that it institute electronic monitoring so that there's no flight from jurisdiction.
Well, that doesn't prevent flight. It may make it easier to detect it.
Well, it's a reasonable step we could take to try to prevent that from happening.
Right. Well, thank you for that. I would hope that you would not want these men to be subjected to the same or worse kind of treatment that Mr. DeBose got.
Absolutely not, no. What we are asking for is lawful punishment, and I don't think that either defendant will appreciate the harm, particularly Corporal Evans, until the cell door clangs shut behind him.
Well, thank you for the State of Ohio's presentation, Mr. Meyer, Mr. DeSimon, and Mr. Susi. At this point, I'm going to take a break, and let's go back on the record at, let's say, quarter after. Is that acceptable to plaintiff?
Yes, Your Honor.
And the defense?
Yes, Your Honor.
Yes, Your Honor.
All right, see you in a few minutes.
All rise.
we are back on the record, and when we went off the record, I think, Mr. Meyer, you were done, but I might as well confirm that. Anything else from the state of Ohio?
I do have two quick points, if you would indulge me. The first is in response to a question you asked about the logistics. Investigator DeSimon, during the break, went down and spoke with Warden Croucher, who indicated that if the court remands one or both defendants to custody, arrangements are made to immediately transport one or both defendants to the Cuyahoga County Jail for the customary period between a transition to the Department of Rehabilitation and Correction. So there would be no time, essentially, where they would be in the Cuyahoga County Jail. Okay. The second point, if you would indulge me before handing it over to my colleagues for defense, I neglected to mention, and I think it's worth considering. In the sentencing memorandum of Mr. Evans, he drew attention to his acceptance of responsibility, and we do take issue with that. There was an exhibit attached to his memorandum, and he went into great detail about the epithets that Mr. DePose spoke to him before the brutality. But what he said next was patently false, we submit. And I'll read it to you. I instructed inmate DePose to be quite, I think he meant quiet. He continued to talk in a disrespectful manner. At this time, I blacked out and hit inmate DePose several times. Your Honor, you've seen the video. He did not black out. That's a lie. And to submit this exhibit as some form of acceptance of responsibility, I think is a gross misstatement, and we do not credit him for accepting responsibility for this document. Thank you, Your Honor.
He does mention in that report comments by Mr. DePose. I guess the mildest of those would be, meet me on St. Clair, you know where I'd be at. Downtown, meet me at the Jack Casino, bitch.
Those are all factual.
That was going to be my next question.
Yes, that's accurate.
Okay, because those were recorded before the camera was turned on.
Yes. I don't think that any of those are misstatements.
Okay.
But the next statement about blacking out, there's stronger language for it, but I'm going to call it untrue here today for it.
Okay. Anything else, Mr. Meyer?
No, thank you, Your Honor.
Mr. Sousa?
Nothing, Your Honor. Thank you.
Mr. Cristal?
Nothing, Your Honor. Thank you.
Thank you all. I guess I'll maintain the same order I've been going in, so Mr. Dixon.
Thank you, Your Honor.
You're welcome.
Your Honor, to please the court. First, I would just like to indicate to the court that I did review the court-ordered pre-sentence report in this case. We would have no objections to the text of that report or no additions to the report itself. I would also note for the record, Your Honor, that we did file a sentencing memorandum for the court. And I also have reviewed the state sentencing memorandum and the sentencing memorandum filed by counsel for Mr. Dugan, all in preparation of the sentencing hearing. And I know that the court has carefully reviewed all documents supplied to it, as this court always does. Your Honor, I guess I'd like to start out by saying, just from the outset, so that there's no mistaking whatsoever, that what you saw in the video, what took place that night in the jail, what my client did was totally improper, it was illegal, it was wrong on almost every level. And Nick Evans would be the first to acknowledge and tell you that, and I think shortly you may hear him say words to that effect. And just touching briefly on what Mr. Meyer just said, Your Honor, about accepting responsibility. It seems to me that there's some part of the state's definition of acceptance responsibility that somehow includes whether or not one becomes a potential cooperating witness to the state. And I would suggest to this court that that should not be a consideration at all. Mr. Evans, on that night, within minutes, in fact, maybe within seconds of the event taking place, said to his subordinate, Officer Dugan, essentially, what we just did was wrong. We're duty bound to file a report on ourselves, and he did. He filed that report that you have attached here to our memorandum as exhibits. If I may.
The one I just quoted from?
Yes, it is.
Yeah,
That was Exhibit E. And, Your Honor, I would ask the court to, again, carefully review that. And anything I say is not in any way an attempt to place any blame on Mr. DeBose at all. However, you have a video. The state has put a context for you for the events that happened that night. And I think it's important also to add a little bit to that. As the court is aware, and I think there's absolutely no dispute by anyone, Nick Evans worked in probably the most dangerous and volatile area of the Cuyahoga County Jail. As we know, that area housed extremely dangerous, often violent, consistently abusive individuals, which often can be explained by some degree of mental illness or another. And Nick Evans served in that environment for a long time and very admirably. We know from the U.S. Marshal study that there are severe institutional problems with that jail. And again, this is not placing blame on any other individual, Your Honor, but attempting to explain what took place that night with this man, Nick Evans, what was going through his head, and the environment and the context of where all this took place, how it took place. I submit to you that what you saw there was a very good man on his very worst day. That is Nick Evans. He started, as we detailed for you in our brief, he started out as a rank and file CO in the Cuyahoga County Jail. Prior to that time, Your Honor, Nick Evans, he's always been a worker. He graduated from Shaker High School. He went on to Kent State University, majoring in a business context. And he's always worked. As one letter that's attached indicates to you, even at age 6, he swept the floors in a barber shop as a young man. And he's maintained a real pride in every job he's done, no matter what it was, working as a line cook, working on the Good Time 3 as a deckhand, and finally as a CO in the Cuyahoga County Jail. Your Honor, he took great pride in all the work he's done, but particularly his work as a CO was always a constant source of pride to him. At some point, he was promoted and given supervisory duties over other officers, again, in this very dangerous and volatile unit on the jail. A unit that was consistently understaffed. Nick Evans didn't complain about that, and he's not complaining about it now. Nick Evans is the kind of guy that he had a job, and he was going to go ahead and do it to the best of his abilities. And I think you can see from his work record and his evaluations that he consistently got good evaluations. Not just good, but excellent evaluations, Your Honor. He was cited by his superiors as someone who had a cool demeanor, someone that could diffuse volatile situations, and did so on many, many occasions. In fact, there's been some mention of Sergeant Tony, and Sergeant Tony authored a letter. That's the gentleman that saw in the video that attended to Mr. DeBose that night. Sergeant Tony authored a letter to this court in support of Nick Evans. And he indicates, as a line officer, Nick was always willing to assist other officers with various tasks. He would take time to speak with the inmates, engaging them in meaningful discussions, offering them sound advice on ways to improve their situations. Nick was also very skilled at verbally de-escalating hostile inmates, avoiding potentially dangerous situations which could have led to confrontations. He's always possessed a calm demeanor, which, paired with his willingness to help others and his desire to resolve conflict, made him indispensable. Having always been impressed with him, I encourage Nick to take the corporal's examination. He goes on to say that after he did, he gained the respect of his subordinates as well as his superiors. And his record bears that out. He had a sterling record in the Cuyahoga County Jail. His only disciplinary write-ups whatsoever were for tardiness earlier in his career. Obviously, he comes to this courtroom with any lack of criminal history. By all accounts, he's been a very good father, very good family man, an excellent worker. This was a very good man at his very, very worst moment, and he'll tell you that. And the state asks you to incarcerate him in prison for this act. Well, Your Honor, I know that the court will consider all factors necessary under the law, including the state's request. But I know that this court, too, will take that only as a request, and this court will do what it sees right and appropriate under all circumstances. The court asked a question of the state, was this sort of thing an aberration in the county jail? And that I don't know the answer to, but I can certainly tell you it was for this man, by all accounts, Your Honor.
Well, the reason I ask that is if the answer is in the affirmative, it might tend to suggest that one or both defendants were a little less inhibited than they might otherwise have been according to their own moral code if they're in this atmosphere where everybody's doing it, so to speak.
Well, as we know, Your Honor, there is surveillance video almost everywhere. Body cams are not, and those do capture activities there. And I think if there were any such behavior, certainly on the part of this gentleman, you'd have that before you here today. But there's not even a hint of it. There's not one inmate that's been brought forward that's complained of any abuse whatsoever.
Well, by Mr. Evans.
Correct.
Right, and my question was not to imply or assume that Mr. Evans had engaged in similar conduct, although if there was evidence of that, I'd be interested in it. But just to wonder whether this was, to use the term, the culture at that jail. And I guess it wasn't really, is my impression. But so that was my only reason for
Understood. All right, thank you, Your Honor. Your Honor, I also want to make very clear, too, and if I did not do so at the very beginning, Nick Evans doesn't place blame anywhere else except within himself. He doesn't complain or blame staffing, lack of staffing, complete lack of, what I would say is complete lack of training for the position he was put in. And again, we've attached for the court the training records for Nick Evans, the trainings that he was given as a corrections officer. There isn't even a psychology 101 course that would equip him to understand in a significant way mental illness and serious mental illness. So, again, when we look at this video, there's no question it's brutal. It's shocking. It's hard to look at. There's no hiding from that at all. But I ask the court to consider, you have a gentleman here, Mr. Evans, placed in this position, often almost alone, or one of the COs almost alone on an entire board with dangerous people, with little or no training to equip them to do this. Nick will never complain about that, though. He went in and did his job the best he could. And by all these accounts and all these job evaluations and all the letters you have in our memorandum, he did that job very well for a very long time. And the one thing that stands out consistently over and over and over is that he was a person that could really talk to these inmates. And he was a person that, in one letter, it indicates from another officer that Nick probably diffused many, many situations of violence by talking down the inmates. That's also in his evaluations. That's why, Your Honor, it's shocking, or it's almost unbelievable that what happened that night did happen, because that is not this man, based on his record. And I ask the court, when you decide what's appropriate in this case, to look at the entire man, to look at his whole, as you might say, body of work, if you will, being a good father, a hard worker, good provider, a really good employee for so long in the Cuyahoga County Jail, laboring under difficult conditions. So I ask you to consider kind of his whole life, and not just this particular moment, which was his worst ever. Nick doesn't blame those institutional problems, but I think I can. And because we know from the U.S. Marshal report that there was, and the state even indicated too, and I forget, I think they said that it was a jail in crisis. And I would certainly agree with that. From staffing to lack of training and all kinds of conditions that really some had nothing to do with this situation. But certainly lack of training and lack of staffing did in the volatile area that he worked in. But he won't point to those. He will and has, from the second this happened, taken responsibility for it. He wrote a report on his own conduct, turned it in, and you can look at the timestamp on it, probably within minutes of when this happened. He did that knowing, Your Honor, that when he wrote that report, he was ending his career as a CO. And you know what, Your Honor? Nick's the kind of guy that I think he knew at that moment he needed to end that career. He snapped. He let his emotions get the best of him. We did not hear on the video the comments that were made to him. They're the kind of comments that, let's say you were outside of a jail situation and you didn't have an inmate that looked like maybe they were ready to fight, as the state indicated, by putting greasing up or something like that on their hands. But if you just heard those comments out on the street and they were directed toward you, they were the kind of comments that are going to easily cause an emotional response. There's no question about it. Does that justify it? Absolutely not. And we're not arguing that it does. But I'm trying to explain to the court why this man, a good man, did what he did in the context he did on that particular night, the worst night of his life. And worst night for Mr. DeBose, I'm sure. He's a express genuine remorse for this incident. There's some discussion about the state, about what I keep hearing, I think, is some lack of cooperation on his part. I'm not aware of anything he's been asked to do that we have not done. I set up a meeting with all the gentlemen and ladies from the state on the prosecution team over at the Attorney General's office some months ago. And the purpose of that meeting was so that they could meet Nick Evans, that Nick Evans could explain to them exactly what he did that night and why he did it. And I wanted to do that so that they could see the genuine remorse that he had and the severe, I guess, self-beating that he took mentally after this. Because he has not, for one moment, expressed any feelings that he should be forgiven for this, but he has consistently expressed true remorse for what he did. He knows what was wrong. He understands there's a price to be paid. So we had that meeting, and I explained to Nick that when we went there, the purpose of that meeting was so that he could face-to-face tell these gentlemen, the investigators on the case, the prosecutors, all of them, what he did and why he did it.
That was post-plea.
Yes, it was. Actually, it may have even been, it might have been pre-plea. It was during our negotiation periods. And it was done, at least for that purpose, because I wanted them to perhaps see Nick Evans live and be able to hear his explanation of this. And I think that afterwards, some comment was made to me that they really felt that he was in a bad way from a mental standpoint. They were impressed, I think, that the condition he was in mentally, knowing what he did, and the remorse that he had was palpable. Your Honor, I've also included in our sentencing brief, and this is not anything that Nick would have wanted me to do, but I think it is appropriate for the court to consider the treatment of other individuals charged with similar offenses. And I know that that is something for the court to consider. We did include in here, and this was not Nick's wishes that I do this, but I explained to him that this is a legitimate consideration for the court in determining appropriate sentence in any particular case. So we've cited to you the case of Associate Warden Ivey. And we pointed out to you, Your Honor, that in that particular case, Warden Ivey was charged with tampering with evidence, felony of third degree, as in this case, and also with falsification, which is a misdemeanor. The indictment, and this is the state's words and not mine, the indictment in this case read that the defendant ordered, and I quote, the defendant ordered a correction officer to turn off his personal body camera during the emergency incident, to wit, the death of Joseph Arquillo. So the officer's personal camera would not capture the audio and video of events as they were occurring. That's the language of the indictment. That's what they allege, and the grand jury found that, and again, this is a warden, Warden Ivey, superior of this gentleman, charged with turning off and ordering body cams turned off during a death investigation. Well, I was in the courtroom when Warden Ivey was sentenced, comfortably out of any harm's way from the criminal system at this point, because the state in that case reduced his charge, allowed a misdemeanor plea. He was given 1 year of probation. I think that the court should consider that, as it must, in considering disposition of other cases. We also had the case of Officer Wilson. I've included for you some documentation regarding that case. In that case, Officer Wilson, and that was case number 639-160, was indicted for felonious assault. He was a corrections officer. In that case, the prosecutors alleged that Officer Wilson slammed an inmate to the floor, knocking out several teeth with such force that one of the teeth lodged in the nasal cavity of that gentleman. Far from reporting his own conduct, as Nick Evans did in this case, Wilson, according to the accounts from the prosecutors, left the victim bleeding in a restraint chair for several hours. Yet, in that particular case, no specific sentence was requested. Those are not cited to this court to excuse Nick Evans for his behavior. And I hope the court will not take it in that context. But it is appropriate to consider the disposition in the other cases. In this particular case, when Nick recorded his own actions, that triggered several events, including the fact that Mr. DeBose would receive medical attention. We can debate whether that medical attention was adequate or appropriate, but that part, I would submit, was out of Nick's hands, Your Honor. He did what he had to do, and that was report his own conduct. And he knew that would set in motion what should have been done, that is that he received medical attention. Whether it was proper, we could not have anything to do with that. We know that the marshal's report came out in November, I think it was November of 18, cited all kinds of problems, staffing problems, things of that nature. But things really never improved. At least not on the night that they were working, that is Mr. Evans. Staffing was still short. He'd not received any additional training. Supervisors did not come down on a regular basis to review the area as they were supposed to. Not blaming any of them, but again, giving the court some context of what this man had to work in. An extremely difficult job. And I submit to you that there's only two people in this room that could really understand what that was like. And that are these two gentlemen in front of you. Because they worked that every night in that jail, day after day. And again, Nick Evans did an admirable job for many, many years. I heard the state also, I think, say that Nick Evans instructed his subordinate to do what he did. I don't think there's any evidence to suggest that whatsoever, and I don't know if that was a misstatement on the part of the state, and I'll just chalk it up to that. But there's absolutely no evidence that he in any way instructed Officer Dugan to do anything. Your Honor, in fashioning an appropriate sentence, and I know this court will, I've asked the court to consider also collateral circumstances, if you will, or collateral effects of a criminal conviction. And there's a lot of them in this particular particular case. We know that as part of this case, Nick Evans will, at the conclusion of these proceedings, officially resign from his position. He's not been on duty since this happened, obviously. But he knew from the moment that he self-reported and filed that, what we think is an accurate and true report of what happened that night. He knew at that point that he was essentially giving up the career, that he was done, and that he should be. Because he knows, because he's a good and moral man, he knows that he could not be in position anymore where ever again his emotions could get the better of him, and what happened could happen again. He knew that, and he understands that. He reached the point that night where he snapped, I submit to you. It was a brief moment that he'll regret for the rest of his life for many, many reasons. Another collateral effect of this is we know that there will be, and he'll face at some point, a civil suit for his actions. The court did rightly ask if there was any issue of restitution. And none having been presented, I think the state indicated that they understand too that there will be civil suits following this. Perhaps, though, Your Honor, aside from those things, and the fact that he will carry a felony record for the rest of his life as well, I think knowing Nick as I do, and I think if you look at the report of Dr. Stephen Newhouse, and I'll spell that for the court reporter, it's Stephen with a V, and it's Neuhaus. Dr. Newhouse worked with Nick at my suggestion and my insistence, Your Honor. He did an evaluation of him, and I think his report gives the court some flavor of where Nick was on this particular night. And I don't want to bring up too many details of his personal life, but there was a marital situation that was weighing very heavily on him at the time. He was under a lot of pressure from that. He had worries about and concerns for what was going to happen in that situation with his 7-year-old daughter. He also had just had the death of a very, very close family member. Nick was under tremendous stress when he entered into the job that night, into the jail. Stress beyond just from that job itself, which I've described, I think, as a pressure cooker every night. But again, year after year, he did a great job there. So, knowing Nick as I do, and as Dr. Newhouse describes it in the report, probably the greatest collateral effect of all this, Your Honor, is going to be the guilt that he's going to carry with him, because he's that kind of man. He's not someone that's going to forgive himself in any way for what he did to Mr. Dugan. And I know he very much, I'm sorry, Mr. DuBose, I know he very much appreciates Mr. DuBose in a very human way saying, I forgive that gentleman. I think that's something that Nick very much appreciates, Your Honor, but it in no way is going to stop the guilt that he's going to carry with him. Nick is going to be punishing himself for these acts for the rest of his life. He feels he's let down himself, his family, people that put him in that position of trust and responsibility. Your Honor, we suggest to you that, or I suggest to you, that considering all the facts and circumstances of this case, considering the background of this man, that he should not be sentenced to prison based on this one night, the worst night of a very good man. That the court should rather consider the entire man, his entire career, his entire life. And I suggest to you that a sentence of community control sanctions will not in any way demean what has taken place. With that, Your Honor, I would leave it to Nick. I think he has some words for the court. Thank you.
On that subject, we can proceed in one of two ways. First, Mr. Evans can be given the opportunity for an allocution, and I would accept it or not. And then I would turn to Mr. Chalupa and then Mr. Dugan. Or, and it doesn't matter to me, I can hear from Mr. Chalupa, and then in order, offer each man the opportunity for an allocution. Do you have a preference?
No, Your Honor. However the court feels is appropriate, it's fine.
Do you have a preference?
I have no preference, Your Honor.
Well, why don't I hear from Mr. Chalupa? So thank you, Mr. Dixon. Mr. Evans, in a moment I will offer you the opportunity for an allocution, but we'll continue with the lawyers, and then, as I said, I'll turn to you, and then Mr. Dugan, and then the lawyer. So, Mr. Chalupa.
May I approach the podium so I could address the
It is
court?
hard to see you.
Thank you. Thank you, Your Honor. Thank you for your time today and listening to the arguments of not only defense counsel, not only hearing Mr. DeBoe's statements himself, but also Mr. Dixon, myself, Mr. Evans, and ultimately Mr. Dugan as well. Just a few housekeeping matters to take care of first. I'd appreciate if you use your judgment to take and incorporate whatever Mr. Dixon has laid out to this court as you see it to apply to Mr. Dugan as well. Also, I did file a sentencing memorandum and provided a courtesy copy to the court last night and this morning. I don't know if you have an opportunity to read it, but my statements today most likely will follow the outline of that memorandum.
I haven't had the chance to read it. It was dropped off on this bench during this hearing, so I do have it in front of me, but I've also been trying to listen to people as they've been speaking, so I will say that I was told it was 58 or so pages, but glancing at it now, I see that 7 pages are essentially your argument. The rest seems to be exhibits. So,
yes, Your Honor.
I will say this. This is of record. By the time I offer Mr. Dugan the opportunity for an allocution, I will have at least glanced at most of it, but I cannot honestly say I will have scrutinized it.
Thank you. And so you know, I will pretty much, my presentation today pretty much will outline what's in that document. For starters, I want to make it very, very clear that not myself, not Mr. Dugan, finds anything that he did to Terrence DeBoe's acceptable in any manner, way, shape, or form. As Mr. Dixon has pointed out with regards to Mr. Evans, this was the worst night and worst actions ever done by my client, Mr. Dugan. He spent 17 years as a Cuyahoga County Corrections Officer, 15 years on the psychiatric floor. As you'll see in Exhibit A of my filing, countless of job evaluations that showed him to be acceptable, if not meeting and exceeding expectations as a CO. While it's my understanding from representing the COs in their union capacity, Mr. Dixon is correct. Training is not, sometimes non-existent inside the county jail. But I do not rest on that as an excuse as what happened in this case. I believe Mr. Meyer, even maybe Mr. Costello pointed out, you don't need training to know that you can't hit a fully restrained and defenseless individual in that emergency restraint chair. And nothing I say today is meant to minimize those actions. Obviously, I will attempt to mitigate some circumstances, but my deep condolences go out to Mr. DeBoe's in this case, and you will hear from Mr. Dugan as well with those regards. Now, as a part of it, you should also know that it was put on the record at the plea agreement that Mr. Dugan had agreed as a part of his plea to resign. I have a dated February 26th signed letter today. I would like to give you a copy of it to make it part of the court's file, but it is his resignation letter, and it will be filed with the county HR department as soon as we're done with these proceedings. The state of Ohio has also obtained a copy of that earlier this morning. I would like to point out, on top of his sterling employee evaluations, in his 17 years as a corrections officer, he had no discipline, he had no allegations of unauthorized, excessive, or unnecessary use of force. I don't think either myself or Mr. Dugan will ever truly be able to explain why he did what he did that night, or what was going on through his mind. It was horrendous. But again, this was one terrible lapse in judgment over an otherwise good career as a corrections officer without any incident. As a psychiatric officer for 15 years, he was responsible and entrusted the care and provided the services to some of our counties, our states, our country's most vulnerable individuals, including Mr. DeBose. As I lay out the rest of Mr. Dugan's history and himself as a person, I'd like you to take into account that this was one egregious blip on an otherwise career and life of a fine man. And I would like you to weigh that as you proceed through the statutory required factors in both misdemeanor and felony sentencing. Some things that I find very important, and the state touched upon it, as well as Mr. Dixon. Mr. Dugan, I've never seen an individual, especially in this line of work, representing these officers, which, for the record, I'd point out, I think these are relatively rare occurrences. We do have pending criminal matters at the time. I think that is a very small percentage of, at the time of this incident, the jail was staffed with around 600 individuals. Now it is upwards of more 715. This is not a common occurrence in that jail. There were well-known and well-documented problems in that jail, but I do not think that this itself, whether or not a culture existed that allowed them to be lax, I cannot say from my capacity that outside of the cases that have been brought before the Cuyahoga County Court of Common Pleas and some very few discipline cases, that this kind of actions were commonplace in that jail. They all knew that these things were recorded. I don't know what it would be like to have your entire actions recorded at all times, but the overhead cameras were almost in every incident of that jail. Mr. Dugan doesn't, as a correction officer, doesn't get a body camera like the corporals, the special response team, or also known as the men in black, or the sergeants do. He did not have a camera, and so everything about whether or not the camera was turned off should not be considered in relation to Mr. Dugan. But I can tell you this, and you'll hear from him, he regrets these actions. He is truly remorseful. When he was confined in the county jail for a period of 2 days after his arrest upon being indicted, the first thing he said to me when I met with him in that jail was, "When do I resign and when do I plead?" And I took that information, or with that mindset, to the state of Ohio as we entered into negotiations in this case. I would like to point out that just like Mr. Evans, they did file a report. They filed a report to Sergeant Tony, in which it outlined what occurred in this case. That was immediate, and they knew that what they had done was wrong. I don't want to get into how they characterized what was going on in their heads, because quite frankly, I don't know if these individuals could really articulate what was going on in their heads. I think saying that they snapped is a little bit more of an excuse than what it should be. I think that's a broad term. I would say that it's unacceptable what they did, and because they pled guilty to felonies, because they've had to resign from their job, it's an appropriate course of action in both of these cases. Again, you've heard from the state. Mr. Dugan will be providing testimony in future cases if needed. He went to the state, was open, honest, really kind of explained the details of what was going on in this particular moment and within that jail as a whole. They've put some of those facts on the record today. I don't feel the need to retread that ground. I have had a a chance to review the pre-sentencing investigation, and you have as well. I'd like to just point out we don't see any need for any changes or modifications to it, but the probation department did find Mr. Dugan to be a low-risk offender, and I would like you to take that into account when you're fashioning and tailoring your sentence in this matter. A few things about the actual offenses that Mr. Dugan pled to. Misdemeanor, simple assault, obviously punishable from 0 to 180 days in jail and requisite potential fines. An attempted abduction, felony of the 4th degree. As you know, a felony of the 4th degree by itself, as long as it's not a violent offense, neither of these offenses under the revised code are considered violent offenses. There's a presumption of probation for felonies of the 4th degree. However, I recognize, and it was outlined in my memo, that this court does have discretion given Mr. Dugan's position as a correction officer, as a public servant, in care and custody of an individual like Mr. DuBose, that if you so chose, obviously following the principal purposes and statutes of felony and misdemeanor sentencing, that you could impose a prison sentence in this case. I am humbly asking that a prison sentence not be imposed, that community control sanctions are more appropriate. You've heard from the various cases cited to by Mr. Dixon and some of the clarifications made by Mr. Meyer with regards to John Wilson and Warden Ivey. I would ask that you consider the facts as they were laid out in the record. But yes, in both those cases, the individuals, one being for an assault case, did receive community control. There's been some talk about serious physical harm. All I want to mention about that is simply when a defendant pleads, they plead to the facts and allegations and admit to the offenses asserted in the charges they're pleading to. Well, misdemeanor assault and attempted abduction do not include an element of serious physical harm. And as well as for discretion when imposing a prison sentence or community control sanctions, that is one of those factors that this court may look at in determining if it is appropriate for a term of incarceration. I ask you to consider that there is no element of serious physical harm, and therefore that element in your determination should not be considered. Now moving on to kind of, as Mr. Dixon articulated, the collateral effects of a felony conviction and sentence. Mr. Dugan is now a felon. He's also now going to be unemployed. I understand that felons are capable of finding gainful employment, and I trust that Mr. Dugan will do every effort to be employed as soon as he possibly can. But I want you to kind of know some other things that have happened in between the time of the plea and today in Mr. Dugan's life. Specifically, his wife, shortly after the plea, and I will read a letter from her into the record. She is not present today because of some serious ongoing medical conditions. And that has, Mr. Dugan's time has essentially been consumed by taking care of his wife. If he were to be sentenced to a term of prison, there really wouldn't be anyone there for his wife. His wife is unemployed. I know that Mr. Dugan is soon to be unemployed, but at least he will figure out a way to maintain his obligations and responsibilities to his family if he's put on a period or a community control sanctions in this case. So if you give me a moment to read this letter from Mr. Dugan's wife, Dana Dugan, D-A-N-A. She asked, Adam, if you could please get this to the judge. I wish I could have been there today to support my husband. Unfortunately, my health is preventing me to do so. I recently suffered a near-fatal heart attack, and I have to wear a life vest. I am also facing a cancer diagnosis due to a large mass found in my abdomen and suffer from severe neck and back issues. With all these health issues come unlimited doctor's appointments, and Tim takes me to each one, as I cannot drive. He does all of our grocery shopping, errands that need to be done, including picking up my life-saving medications. In addition, Tim is my rock. In a few short months, we will have been married 23 years together for almost 26. I'd be lost if he had to be away from home. Tim is an amazing husband and father, and is loved more than words could ever express. in conclusion, before you hear from Mr. Evans, before you hear from Mr. Dugan, I would like to say that when weighing the relevant Ohio Revised Code sections for both misdemeanor and felony sentences, accommodating and taking into account the principles and purposes of each, that the fact that we readily accept that he was in care and entrustment as a public servant in Mr. DeBose not be your sole guiding factor in fashioning a sentence, that his remorsefulness, his immediate acceptance of responsibility, his genuine regret outweigh that one factor of the sentencing statutes. Taking him as a whole, this was uncharacteristic and, quite frankly, an egregious mistake and lapse in judgment of an otherwise long and productive life and long and productive career as a Cuyahoga County Corrections officers. This is not the first case to be sentenced. This is not going to be the last case to be sentenced as related to Mr. Meyer's description of the jail crisis. But while, yes, you should consider what is happening in those different cases, cases should also be judged upon the individual merits of those cases, the individual defendants themselves. And here, from watching that video, it was unacceptable. He never should have hit Mr. DeBose twice. He never should have hit him all. He should have never necessarily gone back into that cell. But for anyone to argue that Mr. Evans and Mr. Dugan were on the same level from what we saw in that video in their actions against Mr. DeBose, that just isn't based on the pleas that were entered, based on the surrounding facts. They shouldn't be treated, there's a lot of things that should be compared together. They were both fine employees, they were both overall decent human beings. But the actions are significantly different. You can see that in the video. I asked that if prison sentences are imposed at all in this case, or any sentence, that take into account that the actions of then Corporal Evans were more significant and more severe than the actions of Mr. Dugan. And with that, I trust this court will abide by all the laws of the state of Ohio and your own good judgment. And I asked, in this case, for Mr. Dugan to be sentenced to a term of community control sanctions. Thank you.
Thank you, Mr. Chaluka. The issue of proportionate sentencing in similar cases has been raised. 2929.11 of the Revised Code does require that sentences in any given case be consistent, and I'm paraphrasing, with sentences in similar cases. Due to the way the court's records are kept, it was near impossible for me to pinpoint similar cases with, and to see what the outcomes were there. So I will say I made an effort to do that, but it was random and anecdotal at best. So really the only cases that I'm aware of that are said to be similar are the ones that have been mentioned, while I acknowledge the differences in those cases that Mr. Meyer pointed out earlier.
Your Honor, may I respond to one question you asked?
Sure.
You asked about culture, and I'm not sure I understood your question initially, but I can only draw the court's attention to the evidence in this case. And jail staff brought this incident to our attention almost immediately. So we infer from that that there are good people in the jail who believe in accountability and doing the right thing. It was, like I said, 1 week after the occurrence that we found out about this. It was the jail staff who brought it to our attention. So in terms of culture, I won't make announcements or pronouncements based on inferences or guesses, but in this case, people within the jail found what happened to be so disturbing that they referred it to us immediately.
Well, again, just to clarify the reason for my question is I was wondering if this kind of thing is so prevalent or so relatively common that these men might have consciously or otherwise felt emboldened to do what they did. So it's a small point. I'm not sure in the end it would have made much of a difference if your answer was different. Something I was curious about. So, Mr. Evans, before a sentence is imposed, do you wish to either make a statement on your own behalf or present additional information in mitigation?
I'd like to make a statement.
You are not only welcome to, you're entitled to. sir, if you do read, keep in mind that the court reporter is trying to take down what you say. It's important that you be accurate for the record on review. The point is you might want to go a little slower than this think you should.
Your Honor, and may I say before he does, I asked him to advise him that he should jot down his words so that he makes sure that he does say or any quote that he contemplates saying.
I would never hold that against a person or take it as a measure of his sincerity or not. I just want to make sure that our record is
Thank you, Your Honor.
good.
Good morning, Your Honor. I'd like to start by saying there are no words to fix what I have done. I would like the court to know that I understand the seriousness of my offenses, and there are no excuses for my behavior. With that being said, I'd like to apologize to Mr. DeBose for the pain I have caused him or his family. He did not deserve to be treated that way. I am truly disappointed and embarrassed by my actions, but I can say that they do not define me. I failed that day. I failed big, but I'm only human. I'm not immune to the stress that life can deal us. I broke, and I'm not proud of it, but it's the truth. I've never ran from this mistake. I ask for the court's leniency. I can assure you that this was an isolated incident, and what happened that day was outside of my character. Thank you.
Thank you, Mr. Evans. Mr. Dixon, if Mr. Evans desires, I can probably sentence him right now and then turn to Mr. Dugan, or I can turn to Mr. Dugan and then continue with the same order.
Your Honor, I'm going to leave that up to the discretion of the court, however you want to conduct your proceeding.
Whatever is easier for you, Your Honor.
Doesn't matter.
No.
So I guess, Mr. Evans, we'll keep going in our same order. So thank you for your comments. I will sort of take them into account when sentencing you in a few minutes. But for now, I'm going to turn to Mr. Dugan.
Thank you.
Mr. Dugan, before a sentences, I should say, there are 2 counts are imposed. Do you wish to either make a statement on your own behalf or present additional information in mitigation?
I'll make a statement.
You're welcome to any time.
Well, my attorney spoke pretty much everything that I would have said to you. So I'm going to get that. Mr. Du Bois is the important one. So I just want to say to you, there's a lot of emotions that day, things said and done. I always thought I had control over my emotions. That day I did. I failed myself. Most importantly, I failed you. I truly do apologize for my actions. I'm genuinely sorry.
Thank you, Your Honor.
Thank you, Mr. Dugan and Mr. Chu. And thank you again, Mr. Meyer, Mr. DeSimone, Mr. Susi, Mr. Dixon, and Mr. Evans. So, Mr. Evans, in imposing the following sentences, well, actually, this is for both of you gentlemen, so Mr. Dugan as well. In imposing the following sentences, I've taken into account everything that I know about you and about your cases. And that's a significant amount of information. First of all, a pre-sentence report for each of you. Second, sentencing memoranda for each of you, although, as I acknowledged earlier, I haven't scrutinized yours, Mr. Dugan, but I certainly know the gist of it. Third, the State of Ohio's sentencing memorandum, which covered both of you. Additionally, I've certainly considered the sentencing laws of Chapter 29 of the Ohio Revised Code, and no doubt I'm taking into account everything said here today by the prosecution and its witness, and by you lawyers, and by yourselves as well. Having considered all of that information, then, Mr. Evans, the purposes of sentencing in Ohio are laid out by statute, and they are, to paraphrase, to protect the public from future crime by the particular defendant in front of the court and others who might be inclined to do similar conduct, to punish the offender, and to provide for the defendant's rehabilitation. let me start with that last factor first. Here, I'm inclined to agree with Mr. Dixon that you are not likely to commit future crimes. I don't expect that there is a need to rehabilitate you. I'm inclined to agree that this was a one-time event. That's the evidence that I have. So rehabilitation, while it is, as I said, a statutory consideration, isn't much of a consideration here one way or the other. As for punishment, however, and protecting the public from future crime by you and others, future crime by you, I think, is unlikely. I think this crime happened because of your relationship, your position of authority in relationship to Mr. DeBose, and, of course, because of this case, that relationship is not likely to exist in the future. But there is a need for deterrence, and there is a need for punishment. Much of today's discussion has been focused on the attempted felonious assault, and rightly so. But the conscious affront to the administration of justice by turning off the body camera is a major concern of mine because, well, in part because it's what I do for a living, but it generates a great deal of distrust, suspicion, and hostility on the part of the public if they think that those charged with administering justice, and of course that does include those charged like you and Mr. Dubin were with providing for the security and well-being of inmates. If people, the public, think that this is what goes on, then the whole system is viewed with suspicion, and the whole system becomes dysfunctional, at least in part. So considering then everything that I know about you and about your case, you are ordered on the attempted felonious assault to serve 9 months at the Lorraine Correctional Institution. You are ordered on the tampering with evidence to serve 9 months at the Lorraine Correctional Institution. These sentences are ordered to be served concurrently, so it is a single 9-month sentence. To be candid with you, I don't believe there's any magic number in a case like this, or to be honest, in any criminal sentencing. I believe 9 months will serve the purposes and principles of felony sentencing. There's probably an argument that the maximum consecutive term would have served those same purposes, or that any amount in between would have served. All I know is that this is a meaningful punishment, period, and the idea is that it is a punishment, and I hope that others who might be inclined towards similar conduct, especially the tampering with evidence, because that was more, to my mind, of a conscious decision. More of, but not the only conscious decision. I hope that others will be deterred. I do want you to know that post-release control is part of this sentence. So when you are released from prison, you will be supervised by the Ohio Adult Parole Authority for 3 years under PRC. During those 3 years, you have to abide by whatever conditions are placed upon your conduct by the parole officer. If you should fail in that regard, then the parole officer has the authority to return you to prison without bringing you to court for a maximum of 4.5 months, depending on how many violations you've committed and what they are. Also during the period of PRC, if you fail to report as required, then the prosecutor may indict you with a separate felony under criminal code known as escape. Finally, if you are on PRC and then you commit a new felony, when you're sentenced for such new felony, you can get as a punishment for violating PRC an extra prison term equal to the greater of 1 year or the number of years then remaining on post-release control. I don't remember off the top of my head, Mr. Meyer, whether post-release control is mandatory here. I think it is because of the offense of violence, but do you have a differing opinion?
I think for the attempted felonious assault it's mandatory, but for the tampering it's discretionary.
Yeah, I think think it is mandatory too. Well, here's what I'm doing. I'm going to inform you, Mr. Evans, that it is mandatory. If it turns out to be discretionary, then you should expect anybody to be pro for it or oppose that. Mr. Meyer, in State of Ohio versus Evans, have I missed anything that I'm required to do under Rule 32?
I believe you covered it, Your Honor.
And is there anything else discretionary that you thought should have been mentioned, Mr. Dixon?
I don't believe so.
Mr. Evans, I never take any pleasure in sentencing any person to prison. If Mr. DeVos had ever appeared before me and I felt that he had to go to prison, I wouldn't have taken joy in that. And I certainly don't take any pleasure in this. I do, though, do what I right in a particular case, and for better or for worse, I think the sentence is apt. But I certainly wish you well in the future, and I'm going to ask that you be remanded to the custody of the Cuyahoga County.
Your Honor, if I may, I have two requests, if I may. One being, given the circumstances here, the circumstance being that he is a former CO in the jail, I'm asking this court to, before having him enter into custody, be assured personally by officials that he will be placed in an area of safety, and before then and having him enter into custody. I understand that the state has done some kind of checking in this regard, but I ask this court to be personally assured of that, as it is the sentence of this court. Secondly, Your Honor, I would ask if the court, and I think I must apply in the first instance to this court, for a stay of sentence pending appeal.
Let me go off the record for a moment. Mullen, who was among the three of you is sort of in charge today?
I am, sir.
The subject, Cox.
Cots?
Yes, Your Honor.
All right, so let me go back. So, Mr. Dixon, in the courtroom are three deputy sheriffs who are employed, well, they're obviously county sheriffs. Of the three, Deputy Cox is the, I guess, the highest ranking. Deputy Cox, were you informed that one or both of these gentlemen may be remanded today?
Yes.
And do you know them? Or at least know who they are?
Yes.
Okay. Were you assured that arrangements have been made to bring them directly from essentially this courtroom to the Cuyahoga County Jail?
I will schedule that with Sergeant Boardman, yeah. They can ride out today, more than likely.
Well, the ride-out part is a potential concern of mine. In other words, there will be at least a few hours, if not more, where Mr. Evans and possibly Mr. Dugan, depending on what his sentence is, are going to be actually in the Cuyahoga County Jail.
Yes, Your Honor. We have to make scheduling arrangements with our staff to get them out there. We can get them out there today.
And
that won't be a problem. I'll assign my staff to transport if that's a concern.
And right now, we're talking only about Mr. Evans, although we may be talking about Mr. Dugan in a minute. Where would Mr. Evans be held for, let's say, the next 5, 6, 7 hours?
To ensure that he has no contact with anyone else?
In the holding cell on this floor?
That's, unless Sergeant Boardman has a place on 10.
Now let me turn to Mr. Meyer. And was it Boardman who made you some assurance, Mr. Meyer?
It was Warden Croucher. Now, I would join, though, in a request to keep him on the floor until the sheriff can make transport arrangements. I think that's a reasonable solution here.
Is there, Deputy Cox, a way to take a detainee directly from a courtroom floor to, I don't know if it's, you call it a bus, a van, or whatever vehicle or conveyance is going to take the person out to Cuyahoga?
Yes, I can schedule that.
Your primary concern is violence by other detainees, correct, Mr. Dixon?
Yes, Your Honor.
Is it also your concern the shame that comes with exposure to his former coworkers, or that's not really what your issue is?
No, Your Honor. He accepts that. He understands that. And as I said, as part of our sentencing, that he feels he's let those gentlemen down. So, no, that's not part of it, Your Honor.
And And Deputy Cox, do you have an estimate, assuming Mr. Evans is remanded, how long he would be in the courtroom holding cell?
I'll get him out there.
An hour?
I can have him out by noon.
Deputy Cox,
12:30.
Deputy Cox, Mr. Dixon was not under oath, but do you have anything in the nature of a cross-exam for him? He's the only person here with knowledge.
No, I would just ask, though, that this court, again, be personally satisfied that what was stated, and I take the officer at his word completely, I'm not in any way doubting him, but I ask this court to be personally satisfied and to assure that those things will take place, given the potentially volatile nature of this sort of incarceration.
Well, I will say, I'm going to trust Deputy Cox when he says that Mr. Evans will be held on this floor, which is a single cell. There is no exposure to another detainee, except unless there's somebody in the cell next door, but that person presumably wouldn't know who Mr. Evans is. And once I go off the record, I can call the warden, and I hope he'll give me the same assurance, essentially, that Deputy Cox just did. Apparently, he has given that assurance to the state of Ohio.
He hasn't. This is not the first jail guard that we've had go to jail. I trust that the sheriffs and the warden will keep him safe. This is something that there is an established procedure to handle.
I would just state, though, if he is going into custody of Cuyahoga County, that there be some assurance that they are aware of this situation. I recently had another client go out there, and I had to personally inform certain persons of the situation and need for protective custody. And I think if I had not done that, I'm not sure it would have happened, at least not immediately. So,
And who did you call in Cuyahoga?
I would have to look back. I called a sergeant.
Well, what's the title?
Whoever was on duty, it was a sergeant.
We'll call as well.
I had a client that was in need of protective custody, got moved from Cuyahoga, and I'm not, again, I don't know for a fact, but I have the feeling that it would not have taken place had I not called ahead of time.
Corporal Clark recently spent about a month out at Cuyahoga without incident, so we'll make the phone call as well.
Well, I'll say this, Mr. Dixon, it's not necessarily your obligation, but of course you're welcome to, once you go off the record, make a similar call again. But I will do what I can, which is really to either trust Deputy Cox and the warden, or if what they're telling me seems to be inconsistent or a little fishy, any further inquiries. But so I guess what I'm saying is I'll do the best I can. On the subject of suspending execution sentence, as I said earlier, I don't do it with relish, but I think this is the correct sentence, and it's going to be ordered today.
So just so the record's clear, Your Honor, I have made a request for a stay, and so that stay is denied then. I need a journal entry before I could ask another court for that.
Well, you're asking that the sentence be stayed.
Pending appeal.
I guess I put that as, well, okay, so you're not asking to suspend the execution of sentence, although you are, you're asking that it be suspended until the resolution of appeal.
Correct.
Yeah, I will include that in the judgment entry that are coming out of today's hearing, which I expect to be signed, I would say by later today, at the latest tomorrow. So, Sheriff, thank you on Mr. Evans. I appreciate it. Sir. Mr. Dugan, I think I already mentioned that in sentencing you this morning, I'm taking into account everything that I know about you and about your case. And I think I mentioned that I'm taking into account the sentencing laws subject to 2020. Having considered, Mr. Dugan, all of that information, you are ordered on count 4, the misdemeanor, to serve 10 days in jail, in a safe jail to be determined by the jailer. this case the sheriff. I'm expecting then that this will be Cuyahoga County Jail based on the conversations we just had. On count 1, felony, you ordered as a community residential sanction under revised code 2929.16A2 to serve 10 days in jail. It's the same 10 days. You have a credit served for 3 days to date, namely April 8, 9, and 10 of last year. So you are going to be remanded today for 7 days. You are notified that you do have the right to appeal. Should you wish to appeal and find that you cannot afford appellate counsel, then appellate counsel will be provided by the state, as will the papers to prosecute that appeal. Is there anything else that Rule 32 obligates me to do on the oral record of sentencing that I've missed in Mr. Dugan's case, Mr. Minor?
I believe you've covered it, Your Honor.
By the way, I failed to notify Mr. Evans of his right to appeal personally. However, his counsel, who does remain present in the courtroom, mentioned the fact of appeal. So while I regret Mr. Dixon overlooking that, it's not an ordinary practice, my opinion at this point is that no harm will come because he's clearly aware as of this moment of his right to appeal. But I do regret not being thorough with your client. Is there anything else that needs to be done on the oral record today as far as you're concerned, Mr. Chiluk?
Nothing by ways of the imposition of the sentence. I would only ask and reiterate the concerns that Mr. Dixon had with regards to Mr. Evans to ensure that he is in safe care and custody at the Cuyahoga County Jail. I would ask that, if possible, the court consider allowing a date for him to turn himself in at the Cuyahoga County Jail to serve the 7 days of the sentence.
Do you have an opinion on that, Mr. Meyer?
I don't believe he's a flight risk. We'll defer to the court.
By the way, this should have been discussed on the oral record at the change of plea hearing, but I don't remember the details, to be honest with you, because it was a while ago. Was a condition of the contract, the plea bargain, continued cooperation upon reasonable request?
Yes, for Mr. Dugan, yes.
And so presumably, if he is given the opportunity to go straight from his house to the Cuyahoga County Jail, and he decides not to, he'd also be violating that condition of the plea bargain?
I don't see that as a realistic likelihood. The Mills case is the case where we would call him, and that hasn't even been set for trial yet. So I think the earliest we would try that case is
Right. So, Mr. Dugan, without objection by the state of Ohio, let me tell you this as your sentence. On count 4, you are ordered to serve the 10 days in jail and with 3 days of credit already given. On count 1, you're ordered to serve the community residential sanction of 10 days in jail as already given with 3 days of credit. However, on count 4, you are also required as a condition of community control to report to the Cuyahoga County Jail on Monday, March 2. I'm sorry, I misspoke. Or no, I'm looking at the wrong calendar. Monday, March 2, no later than 10 o'clock a.m. Mr. Chalupa, do you know the address of the Cuyahoga County Jail?
I do not, Your Honor.
Do you, Mr. Meyer?
Give me a moment, Your Honor.
I'm assuming Mr. Dugan can find it, but of course, it's best to be explicit on the record. Now, as I mentioned, it's a condition of community control on the felony to report to the Cuyahoga County Jail this Monday by 10 o'clock in the morning. If you fail to do that, then you're in violation of probation on the felony, and a prison term of 18 months may be imposed. So there is some additional incentive now to flow that off. If you report as required and do the 7 days, then you've satisfied the conditions of your sentence on count 1, the felony.
Your Honor, according to the Cuyahoga County Sheriff's website, the address is 12450 Merritt Road, Merritt, Chardon, Ohio 44024.
All right, so that's the address we have to report to. It may be worth, Mr. Chairman, after we go off the record, calling the Cuyahoga County Sheriff to confirm that Mr. Dewey should present himself at Merritt Road. Maybe the sheriff wants to see him somewhere else. He's in office or something, I don't know, but that's for those 7 days. Mr. Dugan, I don't consider your conduct here as fraught as Mr. Evans's. As you probably heard, a major concern of mine with Mr. Evans was the conscious turning off of the body camera. Obviously, you didn't do or participate in that. But of course, Mr. DuBose was in a position where there's nobody more helpless in society. There may be people who are equally helpless, infants, the infirm, and so on. But there's nobody more helpless and dependent on others. And so the conduct, while the context, in other words, the statements he was making, give some reason to understand your conduct. They don't provide justification for it. I would never defend what Mr. DuBose was saying. But of course, for better or for worse, and I know you and your colleague had a difficult job, but for better or for worse, that job does require that you restrain your emotions, and then when you don't, it does erode public confidence in the judiciary and in the system of justice, generally speaking. So I believe the punishment is apt, but as with Mr. Evans, I take no pleasure in imposing it. I do it because I consider it my duty. Anything else in State versus Dugan, Mr. Meyer?
Thank you.
You know, I wondered whether I should mention this, but you find yourself in the position of, as a member of the executive branch, prosecuting other members of the executive branch. And yet, the head of the executive branch in our country seems to think what Mr. Dugan and what Mr. Evans did is perfectly acceptable. I have to believe that makes it difficult for conscientious prosecutors and police to do their job. But that's nothing to do with Mr. Evans and Mr. Dugan, so maybe I shouldn't say this. I thank you all. Appreciate it.
Thank you.
All rise.